Hi guys, welcome back to Battle Kwetola. My name is Mujela Oluwa and I'm super thrilled to be here once again. This is a judicial precedent video and I'm excited. You know that I love talking about judgments. It's a fairly recent judgment. It was delivered in 2020 by the Supreme Court of Nigeria. I want to talk about it because it's a very fantastic judgment. It's one that you may say is a judgment of technicalities, although the Supreme Court and indeed the the legal system of Nigeria has repeatedly in recent times, declared that we are now moving away from the era of technicalities. As a matter of fact, I just recently published a paper, an article, not a paper now, a few days ago, I have another paper up on sovereignty and humanitarian intervention. I put it on SSRN now and it's being distributed across some journals, but this article that I recently published a few days ago was me juxtaposing, Omega Bank and OBC, which is a 2005 case, and Baba and Yahuza, which is a 2023 case, where the Supreme Court of Nigeria had to determine the probative value of unsigned documents. I'll leave a link to read my piece in the description box. Please read it and leave comments in the comment section. So in that instance, the Supreme Court departed from technicalities. But in the case we want to talk about today, the Supreme Court embraced and, in a manner of speaking, enforced technicalities. And it will look to the common man that justice, was not done, but the Supreme Court is infallible. So let's look at it and I'll have you make your own decisions. The case we're talking about today is Ude Jones Udeogu and Federal Republic of Nigeria and two others. Ude Jones Udeogu and Federal Republic of Nigeria and two others. So shortly called Udeogu and FRN and us. So in that case, it was an appeal from the Court of Appeal that went up to the Supreme Court. And the appellant was contending that okay, let me give you a background to the case. So, Senator Orji Uzor Kalu was a Nigerian governor. He used to be a Nigerian governor. He was governor of Abia State between 1999 and 2007. When he left office, remember that in Nigeria, governors have executive immunity. We've talked about this whole episode on executive immunity on the channel. Please watch it. So, when he left office, he was arraigned by EFCC. He was charged with several offenses: money laundering, embezzlement, diversion of funds. Specifically, he was accused by the Economic and Financial Crimes Commission of diverting 7.1 billion naira. So he was charged alongside SLOC Limited, which is his company, and Ude Jones Udeogu, who was an aide. When he was governor, he was his aide. So they were both tried by EFCC. It was a 39-count charge. There were even some amendments during the trial, but it was tried over a period of about 12 years at the Federal High Court, which has jurisdiction over money laundering charges and, other ancillary charges for which he was charged. So eventually, he was convicted and sentenced to 12 years imprisonment. His aide was also convicted and sentenced. And the court ordered that his company's SLOC should be wound up and its assets forfeited to the federal government. So that was the decision. And he went to prison indeed. He was held at the Ikoyi prison in Lagos. Then, his aide, who was also convicted, Mr. Ude Jones Udeogu, appealed the judgment on the basis of a technicality. Here's what happened. The judge, in the process, of sitting on the case, was elevated to the Court of Appeal in 2018. And he got a fiat. We've talked about fiat. There are about 2 videos on fiat on the channel. Please watch it. I love how, when we talk about decided cases, many of the topics we've discussed on the channel come together. I will try to remember to put some of those links in the description box, but if I do not, please just look for them on the channel. You can just say Fiat Battle Kwetola in your YouTube and it will bring out whatever we talked about on fiat, as well as other topics. So when he was when he was elevated in 2018, he got a fiat from the chief judge of the Federal High Court, where the case was going on, to continue to sit on the case and to finish it, despite the fact that he was now a justice of the Court of Appeal. and he finished it. During the case, there were contentions that, oh, you're no longer a judge of this court, you can't continue, you can't hand down the judgment, blah, blah, blah. But, he went on armed with the fiat and he handed down the judgment. And then Ude Jones, who was one of the convicts, then sued to quash the judgment on the basis of that technicality, to say that the judge had acted ultra vires, that is, above or beyond his powers. There's a video on ultra vires too, I believe. Even if there's no video, we've talked about ultra vires. I always mention it on the channel. Ultra vires, ultra vires. It's a Latin term that means above powers, beyond powers. So he was contending that the judge had acted beyond his powers because he was now a justice of the Court of Appeal and could not come back to sit in the Federal High Court, as he was now person non grata, so to speak, at the Federal High Court. So he went up to the Supreme Court, and the Supreme Court agreed with him and then nullified the conviction. Of course, because he was not the only one convicted in the judgment, the entire judgment was nullified. So Senator Orji Uzor Kalu became a free man, and essentially the judgment was nullified in its entirety because of that technicality. Today he's still a free man because, the court actually ordered that the case should be returned to the Federal High Court to be tried de novo. De novo means to be tried afresh. We've talked about that on the channel as well. It means to be tried afresh. So the case was ordered to be tried afresh. But since that time, since 2020, when the decision of the Supreme Court was made, the case has not been tried de novo. Now, Senator Orji Uzor Kalu has even gone to court to contend that trying him afresh amounts to double jeopardy, and EFCC has contended that it is not, and is seeking his retrial as we speak. So that process is ongoing. It's been about 5 years since the judgment was quashed, so you would really wonder what is going on in Nigeria. And this fellow is now a sitting senator, making rules and regulations, making laws, which will lead me to the bone of contention, actually, that led to the question of the judgment. Now, the legislature of Nigeria, which Senator Orji Uzor Kalu is now a part of, had made an act or a law that I've referred to severally on this channel, the Administration of Criminal Justice Act 2015. That act was made to speed up the process of criminal litigation and adjudication in Nigeria, and to cater to so many loopholes that the Criminal Procedure Act or Criminal Procedure Code and the criminal laws of various states and that of the Federation could not cater to, some of the things, the loopholes that were being exploited and some of the things that were causing delays. The law was supposed to ameliorate them or to even resolve them in totality. But this was the law that bailed out Ude Jones and Senator Orji Uzor Kalu. I'll explain. If you check Section 396, subsection 7 of the Criminal Justice Act, it provides that, if a judge has been elevated, he can come back by fiat to finish the criminal matters that he was doing before he was elevated. Let me read it out to you. Notwithstanding Section 3967, notwithstanding the provision of any other law to the contrary, a judge of the High Court who has been elevated to the Court of Appeal shall have dispensation to continue to as a High Court judge only for the purpose of concluding any part-heard matter, criminal matter pending before him at the time of his elevation, and shall conclude the same within reasonable time. So you know that the Federal High Court is a court of first instance, so it can pass for the High Court in the instance of this case. So on the basis of this provision of the Administration of Criminal Justice Act, you would look at, what's the rationale behind this. The rationale is that when a judge is elevated, it goes to the new jurisdiction, the new cadre, the new court, the higher court. So now cases that were before him have to be started de novo. My team experienced this because when our judge, we were in court 13 for several years, and when Justice Elegani was elevated, we had several cases, in fact, tens and tons of cases before him, part-heard. Some we were even close to closing the case. Some were ad-fort criminal matters. But because of what had happened in the Supreme Court decision, which essentially nullified this provision of the ACJA, of course, he could not come back to continue hearing them. Those cases had to be tried and started de novo because of things like this. Time is wasted, faith is lost. If you are a nominal complainant, and maybe you were at the point of getting judgment, or both parties have closed their case, or it's been a hard fought and long fought criminal litigation, and then the judge is elevated at that point, what then happens to you, to your to your faith in the judicial system, when you hear that the case will have to start afresh just because the judge has been elevated? So the ACJA sought to cater to this anomaly, but in this case, the Supreme Court held that the ACJA, that provision, is unconstitutional, because when you now look at the Constitution, they went back to look at Section 249 to 253 of the Constitution, which makes provisions regarding the Federal High Court and the constitution of the Federal High Court, who can be a judge, how many judges, and there's even a provision, if you check Section 252, that gives or clothes the legislature with power to make extra laws, to enhance the efficiency of the Federal High Court. So the respondent contended in this appeal that that provision, suffices or caters to the fiat issued by the Chief Judge of the Federal High Court, relying on Section 396 of the ACJA to say that you've been elevated, but this is a case that has been ongoing, and you need to conclude it and give judgment before you go. So I'm giving you permission, fiat. We've talked about fiat. I'm giving you fiat to conclude this case and then go and continue your business in your new court, in your new in your elevation in your new court. Now, Ude Jones now contended against the contention that this provision is to cure the anomaly of cases being started de novo. And Section 252 of the Constitution also says that the legislature can make extra laws outside of the Constitution to help or enhance the efficiency of the Federal High Court. And so this provision is part of those laws. Ude Jones now contended that that is not the intendment of Section 252 of the Constitution, that the intendment is as to who can sit and as to the jurisdiction of the Federal High Court. So if you are no longer a judge of the Federal High Court, that section does not affect you or apply to you. So the legislature can make laws to maybe extend the tenure of, or to decide who can sit and how many judges should sit, essentially the jurisdiction of the Federal High Court. But it was now contended that the judge, in this case Justice Idris, who is now a justice of the Court of Appeal, has been elevated. So this is Federal High Court, where he was sitting on the embezzlement fraud matter filed against Orji Uzor Kalu, Ude Jones, and Slock. Now, this is the Court of Appeal. The case had gone on for about 12 years. Then it was elevated to the Court of Appeal. Now, they are saying, the Chief Judge now said, you have been elevated, but by Section 396 of ACJA, come back and finish your case, and then go on with your journey, your judicial journey. Now, he did that. Now, Ude Jones, who was a convict in the judgment, is now saying that Mr. Justice Idris, respectfully, you have been elevated. That means before this Federal High Court, where we are being tried, you are no longer recognized as a judge. You are now a new person, a brand new man, a justice of the Court of Appeal. No fiat can make you come back or give you the leeway or latitude or the legal ground to sit on our case as a judge of the Federal High Court, because you are no longer a judge of the Federal High Court, essentially. You are a changed man. You are now a justice of the Court of Appeal. So if it is now being contended that Section 252 of the Constitution says that the legislature can make extra laws for the Federal High Court to and that is why they made the law and said that you can come back to finish your case before you go. No. Yes, they can make extra laws, but those extra laws will affect people that are still judges of the Federal High Court, people that are still judges that have not become justices of the Court of Appeal. Do you understand? So these were the contentions before the court. Of course, the Supreme Court agreed with Ude Jones to say that Justice Idris was now a justice, no longer a judge, so he could not act. And then the Supreme Court essentially declared Section 396 of the ACJ unconstitutional. So you see what is going on. The legislature made a law to enhance or to expedite action regarding criminal matters and the adjudication of criminal justice, administration of criminal justice in Nigeria. Now the Supreme Court is saying what you have made, the law you have made is unconstitutional. You don't even have the latitude to make such laws. So you cannot convert a judge that has been elevated back to a judge of the court where he has been elevated from. So essentially, that's what happened, and the judgment was quashed and returned to the trial court to be started de novo. What do you think about this case? Did you see the interplay and the various contentions? One would then wonder, did the legislature not understand this? Honestly, I think that this may not have come into contemplation when the law, the ACJA, was being made, and there are some provisions of law that you would never know how efficient or effective they would be or how problematic they would be until it is put to the test. It was just unfortunate that it had to be put to the test in a case that then discharged, people who had been accused and successfully convicted of embezzling the commonwealth of their state. Today, they are free men. The FCC is still trying, to get a retrial, and one of them is a sitting senator in the same chambers where the law that he quashed, or that the law that freed him, the technicality that freed him, where it emanated from. So this is what happened in Ude Jones. It's a very fantastic case. It's a case that I've read over and over again over the years, and I just thought to share. So let me know your comments in the comment section, and I will see you in my very next video. Don't forget to subscribe. Toodles!